Hello, everyone. Good afternoon to you, and welcome to the first in what is intended to be Mercantile Barristers' series of webinars on adjudication. So today we are going to be addressing how we can deploy the mechanism of adjudications in resolving construction disputes and therefore preventing delays to make construction more efficient and successful. Put quite simply, the primary objective of anyone involved, or in fact, each and every person involved in the process of construction, is just to get the building built. But more often than not, we find that disputes that arise in the course of the construction project ends up frustrating the project. Adjudication could, if very skillfully deployed, be used as a means of actually preserving the project and making it successful. Hence, we're putting on this series of adjudication webinars in order to assist our clients. So we kick off today by way of introduction. In case you haven't been to any of Mercantile Barristers' webinars, my name is Samuel Okoronkwo. I'm, of course, a practicing barrister, used to be a quantity surveyor and a project manager. Therefore, have actually got my both feet and hand muddy, as it were, before coming into the law and then practicing in construction. So, taking you back into adjudication, therefore, disputes and delays are often the biggest risks to project success. Now, project success actually is achieved when the project is delivered on time, within budget, and to the specified standards. But as I'm sure each and every one of you involved in the course of construction will be well aware, disputes more often than not raise its head because, of course, there are a myriad of stakeholders and thousands of materials being deployed every day by using various skill sets and equipment. So labor, plant, materials interacting to achieve what the architect has designed results in disputes. So how can adjudication prevent escalation is what we're actually looking at. So we deploy adjudication as a tool by way of early intervention, bringing adjudication in on time in order to prevent project delays as a result. So why do disputes arise in the course of a construction project? When you look at it strictly, they relate to, in the main, late or withheld payments. Often they originate in poor drafting of contract documents. Clearly, in most standard forms of contracts, the phraseologies are standardized, but frequently practitioners tend to seek to amend specific clauses to achieve particular effects. And it isn't surprising that if it is not done properly, that the aim of amending standard clauses can become counterproductive. Now, there is lack of clarity more often than not with the specifications, so the scope is not fully defined. And there are, of course, variations that keep happening during the course of a construction project. So the client could change their mind. The architect and indeed the designers involved can realize that they have not been as specific in their specifications or detailing. And when they introduce what they had sketched earlier in greater detail, it amounts to a variation for which a contractor would be ordinarily entitled to be reimbursed for any extra costs incurred. The next will be why disputes arise is that the construction program is beginning to slip. And if you're missing key milestones and targets, then the project duration begins to extend and the disputes begin to rear their heads if completion dates will not be met. And as I've already referred to, design changes. There could also be quality issues and the defects that arise when things are not built properly. So those are the key reasons why the disputes arise. But once the disputes have arisen in the construction project, what do? You should seek to resolve all these disputes as soon as they become apparent. Do not wait until the end of the project before you start trying to resolve your disputes. If you do not resolve the disputes as soon as they arise, you end up facing the costs that will arise out of delay. So you will encounter cash flow strain because the contractor is running out of liquidity in sustaining the program. So there will be a depletion in the labor on the number of men and crafts operatives on site. There will be a decrease in the delivery of materials, and you're beginning to see telltale signs that the contractor is suffering a cash flow strain. And the cost of delay could even lead to insolvency. Of course, if materials are not being delivered on time or in reasonable quantities, and the operatives are not on site, and the number of men and women that you require to do the construction work, the program will begin to be disrupted. You will begin to miss key milestones. And when key milestones are beginning to be missed, the likelihood is that the project completion date is then at risk. If the project completion date is at risk, you can see larger disputes coming. You are then into potentially legal escalation if you do not immediately resolve it. So one takeaway from this webinar today will be to say, look, do not have any hesitation in deploying adjudication promptly as soon as a disagreement has arisen, as soon as a dispute has arisen. But one of the key things to ensure is that a dispute has in fact crystallized before you can adjudicate. And this is something that I will return to later. Now, adjudication, therefore, as a preventative measure. One of the key benefits of adjudication is that it's a quick dispute resolution process. It can be accomplished within a 28-day timescale. That is incredibly fast when you compare it to how long it would otherwise take you to go into arbitration or indeed litigation. That will run into months and often can exceed 1 year, depending on the complexity of the dispute. But compare that with getting a dispute resolved within 28 days, and that is rapid. You could do that whilst the project is still ongoing, and therefore not prejudice the completion date, not obviously prejudice the relationship between the parties. Now, as you keep your projects moving whilst you're resolving a particular disagreement in adjudication, you will find that ultimately it leads to greater good in the sense that the project outcome, the objective to build a project successfully, is safeguarded. Now, adjudication ensures that payment security is relatively enforced because of the very nature of adjudication, which is that once the decision is made, it is binding pro tem. You have to obey that decision before you can argue later. Now, it discourages bad practice because historically, prior adjudication, it is not unknown that certain either main contractors or developers will withhold payment for the sake of withholding, well, not necessarily for the sake of withholding payments, but they will see it as preventative, as conserving cash. But the flip side of it is that they're then starving their own project of the liquidity that it needs to progress. So as a preventative measure, it can be deployed very quickly once the project is active, and it will give you an answer within 28 days or thereabout, depending on the party's willingness to either extend time or otherwise. It will keep the project moving on, it will enforce discipline, and it will discourage bad practice. Now, so the proactive use of adjudication will act as a disciplinary mechanism for both employers and contractors, because it would impose you that once the decision is made, you have to abide by it. You have to pay now. You can argue later. It also assists with the clarification of contractual rights and obligations midway during a project life cycle. You do not have to leave all of the disputes that have arisen in the course of your construction project to the end. If you can imagine that if you leave your project disputes to the end for it to be resolved, it can only mutate and become even more difficult. Memories fade as well, and positions become more entrenched, and the incentive to resolve it, it becomes less and less. But once the parties are, as it were, in the eye of the storm, they're in the thick of it, getting on with the project, people are more likely, if a decision is made against them, to swallow it, compromise, and then move forward. Okay, now it provides, I put it down here as leverage for settlement. Per se, because you have to pay now and argue later, the incentive to refuse to payment disappears, because if you do not want to pay now, then you are then faced with enforcement action. And the natural predisposition of the court is to give effect to adjudicators' decisions. So the courts will be more inclined to enforce rather than not enforce. In fact, it is roughly 70% of the enforcement proceedings that are brought in the TCC is successful, and therefore it's only in exceptional circumstances that they will be reluctant to enforce. But then that is a matter for another webinar. Okay, it prevents disputes from becoming project ending. If you deploy adjudication very well, you will find that whilst your project is ongoing, you're maintaining the relationship, you're maintaining the confidentiality between the parties, there is still a willingness to push to the end of the project, then it's effectively deployed. It doesn't, the dispute that has arisen in the meantime does not become project ending. Therefore, it's not a case of everyone down tools and parties retreat to their fighting positions, spend 6 to 9 months fighting whilst the project site is lying stale. Adjudication effectively deployed whilst the project is still ongoing will ensure that such negative scenarios that lead to project ending are avoided. So typical scenarios that you then have, payment disputes are resolved quickly. That protects project cash flow. Even when delays have arisen during the course of the project life cycle, if you can address extensions of time once the issues causing the dispute is live in everybody's mind, you will find that you can actually resolve it rather than wait 10 weeks after the project is finished. That is when the contractor realizes that they have to make an application for an extension of time, which then the project manager and or architect takes just as long a time to determine. Now, people are then dealing with matters retrospectively. Why not, as soon as it becomes apparent to you, which is indeed what the contract documents will provide, that as soon as it becomes apparent that the project will be delayed, you should give appropriate notices that there will be delays. And indeed, once you're giving notices, why don't you then seek your extension of time? And if you're an architect or a project manager on whose lap it will fall to make a decision as to whether an extension of time is to be granted or not, why not, as soon as you receive that application for extension of time, consider it contemporaneously, make a decision then. If you're going to extend the end date by 2 weeks or 2 months, make the decision now. So there is a reprogramming and there is a clarification between the contractor and the employer, and everyone is clear in their mind what they're going to be getting at the end of the day, rather than wait to the end. Now, defects issues are also dealt with in adjudications, but less so than the payment and time extensions. But if the defects arise in the course of construction, you try and resolve it early to avoid having to, as it were, rework the construction process. So if you notice that if, for example, a sample panel has been put up and what is built is not in accordance with the sample panel, deal with it at the time and don't wait for it to, as it were, linger. and it can be dealt with in adjudication to resolve the issue. So what are the benefits, therefore, for the stakeholders if they mutually deploy adjudication properly? For employers, the biggest risk to your project is delivering it on time. Now, if you deliver it on time and the budget is slightly out, most employers could cope with that depending on the project budgeting and whatever contingencies that might have been built up in the budgeting. But if you have overrun programs significantly, not only is the budget under pressure, there is the loss and expense and the extension of time and the prolongation costs that will follow. So for the employers, the key benefit of adjudication is that if it's deployed well, it can give you program certainty. If you have program certainty, the risks to the project is that much reduced because of the key cardinal points of time, cost, and quality. Time is safeguarded. And for contractors, it is said that cash flow is the lifeblood of construction. If adjudication is skillfully deployed and timely and efficiently managed, cash flow lifeline could become preserved and protected. There'll be faster dispute clearance. Cash, which you require to build a project, will be more readily available because where there is a dispute as to payment, instead of downing tools, parties resolve it contemporaneously. And it is said that one of the key causes of adjudication, or one of the key causes of adjudication, includes exaggerated claims by contractors. So whilst contractors are encouraged to make claims reasonable and not exaggerated, the timely resolution of claims made during the life cycle, during the construction process, would ensure that cash flow is preserved. And that is a major benefit to the contractor. And to the consultants, who to a large extent are the ringmasters here, in that under the standard forms of contracts, the employer is largely silent. The contractor is active building the project, and the consultant often has the burden of delivering all of the liabilities, or you said the obligations that the employer will have to do, i.e. design and manage the project. Now, the consultants are exposed to potential professional negligence claims. If during the project life cycle issues arise that the consultant takes hold of and is able to determine it clearly, it's far easier, I find, in practical experience, to explain that to a client and say, A, B, C, D happened, as a result of which we're going to extend the contract end date by 2 weeks or by 4 weeks. It may well be that it was a client-induced change, which the consultant, the architect, has incorporated, which is then leading to the extension of time. It is far easier to explain it to your client as it is going on, whilst everyone is seeing the project making reasonable progress, rather than wait until X number of months after practical completion has been achieved. Because it is not unusual that your employer, the client, will turn around and say, well, you were the architect. Why didn't you think of A, B, C, D, E at the beginning? These things are nuanced. There's not a clear fine line, and they're often fact specific. But the key benefits are that if you deploy adjudication properly, you will be able to reap the benefits, and the benefits are evenly distributed, for want of a better expression. It is a win-win for all the parties. It may well be that the employer is ordered to pay a bit more money than the employer had intended to, but ultimately, the opportunity cost of not paying that promptly may well be the prolongation of the contract duration, which in itself is more harmful to the client's and the employer's interests. And so contractors benefit, employers benefit, and consultants benefit. So it is win-win for all, and that is only to be encouraged. Now, pitfalls then, if misused. Now, if adjudication is misused. Often you encounter poorly drafted notices. Now, when you poorly draft the notices in adjudication, you expose the adjudication and therefore the adjudicator to their jurisdiction being challenged. And that could be good grounds on which to oppose enforcement of the adjudicator's decision. So before commencing adjudication, it's imperative to be clear in your mind at what you're seeking to achieve and ensure that the notice that is drafted to kick off the adjudication process is appropriate and precise. Further, if you are going to deploy adjudication, it is ultimately essential that you avoid evidence gaps. So if you're going to make a claim, collect the necessary evidence, have the information to hand. So if, for example, you are saying that there has been a variation that led to an increased cost, you should be readily having in hand the details of that which you had at tender stage, what it was you priced at tender stage, what it is that you're now being asked to do, and when it was that you're being asked to do it, such that you have the full information that is required to present your case neatly, so that it's easily understood, not complicated in any way, but it follows as clearly as any sensible person looking at it will appreciate it. Also, avoid serial adjudications, which could lead to fragmented results. Now, at this point, I tend to mention that it's necessary to appreciate that adjudications usually should deal with one dispute at a time. And clearly, you cannot adjudicate the same dispute twice. So ensure, therefore, that you do not try to squeeze in multiple disputes into one adjudication, because that in itself will invalidate the adjudication. So we make progress from here. Now, often I find that when adjudications are brought to my attention, the specific value that I think that counsel can add to it, because on a day-by-day basis, the project participants, the contractors, the engineers, the project managers, the quantity surveyors, the architects, and the employers, the developers, are the people dealing with it day by day. Now, when you want to proceed to resolve an issue of contention, where counsel helps you is to advise you and guide you on the case strategy. Short, sharp, nothing complicated or prolonged. And also, counsel assists you in drafting your notices appropriately. Now, the fact that you have made a payment application that has not been paid or has not been paid on time may well indicate a dispute, but has that dispute crystallized? You have to take steps to ensure that you extract from the other side an opinion as to what it is that you're claiming, and if there is an agreement or a disagreement. And indeed, if there is a disagreement, to what extent is there a disagreement? Now, counsel will also assist you in ensuring that the jurisdiction in the adjudication that you're beginning is safe. And that is to say that whatever disputes you're bringing to adjudication and the steps you have taken to initiate and commence the adjudication will ensure that the adjudicator's decision, if it's in your favor, is enforceable. And in fact, conversely, if you are at the receiving end of the adjudication, are there any openings in the adjudication that has started that could assist you in challenging the jurisdiction of the adjudicator? If there is one, reasonable counsel should be able to pick that out for you. Now, counsel will also assist you in building a focused, persuasive submission, because your adjudication largely will be in writing and on paper. So advocacy, although is spoken, is also largely written. And it is the case you present and the arguments you run and the evidence that you have extracted in support of that argument that will assist the adjudicator, who was not on site when all this was going on, but can only read from the submissions you've made to assist them in reaching a decision. And this would also ensure that if you have counsel assisting you where it's necessary, depending, of course, on the value of the claim to justify the involvement of counsel, it would ensure to a large extent that you can secure enforceability or enforcement of the decision you've secured in your favor in the technology and construction court, should that become necessary. But increasingly, we're finding in the statistics that those who are on the receiving end of adjudication decisions are more likely to comply rather than seek to resist it, particularly if those adjudications are brought and resolved whilst the project is still live. Clearly, the disposition to, as it were, resist enforcement of the adjudicator's decision is more likely that when the parties have left site and project is no longer in progress. So key takeaways, therefore, disputes and delays are inevitable in the construction life cycle, as we are all well aware, but escalation of those disputes and the delays is at all not inevitable. We can avoid the escalation. We can deal with these disputes, remain friends, and move forward because we deploy adjudication properly. So adjudication is a very powerful prevention tool if we can deploy it properly. So you want to start right, ensuring that you're going at the right speed, and certainty and enforceability can then be achieved mutually. I say, as I said before, this is not one I win or you lose. It's a win-win for the parties, provided it is properly deployed. So at this stage, I open the floor, as it were, for question and answers. This is supposed to be an early introductory webinar, and we're in our series. I believe there are half a dozen more seminars, webinars to follow this. We'll then go into the nitty-gritty of adjudication. So, for example, our next adjudication, the date of which will shortly be announced, will address the running of an adjudication, how you can strategize properly, deploy the appropriate tactics and the advocacy that you require in order to achieve success. So if I draw stumps at this stage and then invite questions from the floor. So the first one I see is adjudication a last resort? Does it ruin relationships in an ongoing project? Now, often litigation, to my mind, should be the last resort, not adjudication. Now, adjudication, if you're giving it steps order 1, 2, 3, I will say once there is a disagreement, a dispute that has crystallized, adjudicate immediately and indicate to the other side that the adjudication does not mean the ruining of the relationship or disruption of the project that is going on. You say, look, you and I disagree on this. An adjudicator who will informally and rapidly give us a decision would better preserve our relationship. And most reasonable people would agree that in life, and indeed in business and in project management, it's not my way or the highway. It is either my way or the way that we can mutually agree, failing that, the way that a third party could assist us with. And if an adjudicator can do that and save us the substantial expense of going to arbitration or litigation, adjudication, therefore, is not the last resort. It's not the first resort. The first resort is to try and negotiate with the other side. But when negotiation is not getting anywhere, have no hesitation in adjudicating. The second question I have here is from Christopher. What happens if the dispute has happened a month ago and we have not found the time to do adjudication? Now, that's actually a very, very common situation, because when matters come to me, I tend to ask either the employer the architect, project manager, or the contractor. And I say, why did you not attempt to resolve this at the time? We were going at the speed of light. We had no resources. We had no time. Everybody, the stampede was to chase and meet the program. Now, that is often the case. And as such, it is necessary that when it is realized, if you need external help, get it. But resolving it contemporaneously is far more advantageous, valuable, cost-effective than leaving it. Now, if the dispute happened only a month ago, it shouldn't be the end of the world. But I would say don't leave it any much longer. So to Christopher, what happens if it's happened a month ago? If it's happened a month ago, please still adjudicate it, but don't leave it running. If you leave it running, it gets more difficult. Okay, I have another one. We have a contract, but we don't know if it allows for adjudication. How do you find out? It's interesting because in England and Wales, and definitely in Scotland, and one can safely say in the United Kingdom, adjudication is statutory. So whether or not it's written into your construction contract, provided it's a construction contract, the Construction Act introduces adjudication into it. And in fact, it's a groundbreaking legislation which ensures that all construction contracts are required to have adjudication provisions within them. But if they don't, the Act introduces them. So whether or not it's in your contract, you can still make a referral. A referral is inviting an adjudicator to come in and resolve the dispute. So that answers the question, which I see has come from Alea. I see another one. I wonder about the cost of adjudication as opposed to any dispute we may have. Don't both sides just open themselves up to more legal costs? That is a matter of reality. Clearly, before going to formal dispute resolution, good business people ought to attempt to resolve their dispute by negotiation, because it is clear to you that once proceedings are brought against you, you will be obliged to defend yourself. So the cost of bringing the proceedings as well as the cost of defending yourself should both be considered. But regrettably, people often fail to reason objectively. They hold their entrenched position until the dispute begins to fly and fester. So the cost of the adjudication could be sizable. Clearly, if you're doing it yourself, it will not cost you as much as if you're using professionals to do so. But then if you're doing it yourself, you then have to weigh up the likelihood of you getting it wrong, because let's face it, you're not in the business of resolving disputes yourself. You're in the business of building buildings, either as a developer or as a contractor. So costs have to be considered, and the costs are sizable. They should be considered, but the costs are far less than arbitrating or litigating. The cost of going to court is significantly higher than the cost of adjudicating. So both sides do open themselves up to cost. And interestingly, adjudication by its very nature does not make provision for you to recover your costs. But the adjudicator may be given the jurisdiction, the permission by both parties to determine who pays the costs of the adjudication. But unless the parties agree to give the adjudicator that jurisdiction, he has no power. It's a case of, it's short and sharp, quick and dirty. Decision is made. You bear your costs, I bear my costs, and we move on. And indeed, it is hoped that that provision, that you bear your costs, I bear my costs, will either act as a barometer to enable people to think more sensibly before they begin an adjudication or otherwise. Okay, so that's it to do with the cost of adjudication. What other questions do I have? What happens if I don't agree with the adjudicator's decision? Do I have to pay the adjudicator's fees? It's a double-barrel question, that, but the answers will come like this. Both parties are jointly and severally liable for paying the adjudicator's fees. So the adjudicator will ordinarily split his fees in two for you to pay 50-50, albeit that it is often on the referring party to pay it and recover it from the responding party. But if you do not agree with the adjudicator's decision, you are still required to obey it. Now, the situation is slightly different if you've challenged the adjudicator's decision, the adjudicator's jurisdiction at the outset. If you challenged the jurisdiction, by that I mean as soon as the referral notice is received and the notice of adjudication follows, the notice of adjudication first and the referral notice comes, you look at it and you say, look, there is a defect in either the notice or in the adjudicator's appointment, or indeed the adjudicator has in some way conducted himself such that his bias is manifest or he hasn't followed the rules of natural justice. You can challenge the validity of the adjudicator's appointment or indeed of his overall jurisdiction. If you have taken that point, most adjudicators will take the initial step to determine their own jurisdiction. So if the adjudicator listens to your complaint about his jurisdiction and agrees with you that your complaint is valid, the adjudicator will step down at that point and that adjudication ceases. If the adjudicator, which is more likely, looks at your challenge to his jurisdiction, disagrees with you and says, look, I'm properly appointed, I have the jurisdiction to determine the dispute that has been referred to me, and then proceeds, then you have options. You may decide not to participate in the adjudication, which would be unwise. You may choose to participate in the adjudication on the protest. And you're saying, look, I don't believe you have the jurisdiction to do what you're about to do, but I'll participate and reserve my position. If you've taken that position and you end up not liking the adjudicator's decision, you may then choose to challenge it in the courts. And if you challenge it successfully, or in fact, your challenge of it, because you've reserved your position at the outset, gives you an opening to resist the enforcement of that decision. You do that through Part 8 and Part 7 proceedings in the courts. And you may then be successful, depending on how good your argument is, both on the facts and on the law. So if you disagree with the adjudicator's decision, unless you have reserved your position to challenge his jurisdiction in the courts, the answer is that you must still abide by it. And it's only when you have obeyed it that you may then seek to have that same dispute resolved either through arbitral proceedings or through legal proceedings, but you may not re-adjudicate the same point. The next question I have is on the cost point. Doesn't the bigger contractor with the bigger budget always win? Suffice it to say that the larger contractor with the larger budget is likely to have professionals deployed, but it doesn't mean that the smaller contractor always loses. It depends on how determined the smaller contractor is and how dogged and how they have actually assembled the evidence in justification of their position, because the facts and the evidence trumps everything. So if a large contractor who lacks facts and lacks evidence brings their excessive resources to bear, it still doesn't change the facts, neither does it change the evidence, and therefore it is not true that the larger contractor would always win, and considering that both parties will bear their costs. So clearly there may well be what one could best describe as inequality of arms in terms of availability of resources. But then again, the resources to be deployed must always be proportionate to the value in issue. There will be no benefit to a contractor who has large resources to deploy a disproportionate amount in trying to resolve a small dispute. Might even be wiser just to negotiate and make a reasonable offer of settlement, which will be acceptable. Okay, so now those are the questions that I have so far, and we've just been running for, I believe, a few minutes under an hour. If there are any further questions, I would happily deal with them. But absent those questions, it will fall to me to thank you for attending and for listening and watching this webinar. Our next webinar, as I say, will be addressing the actual running of an adjudication, the strategy, the tactics, and the advocacy in ensuring that your adjudication is successful. Whilst that presupposes that you are the referring party, there will also be good nuggets in there for you if you're the responding party. If the, as it were, the referring party presents you with a case, what is it that you do? How do you strategize your response in order to bring a more successful conclusion from your point of view? So as we are a few minutes short of an hour, the intention is not to keep it running for any longer than necessary. If there are any further questions, I'll take that. But otherwise, I will thank you for your attendance and participation and look forward to seeing you in our next webinar. Thank you very much, and bye-bye.